The intrusion of discordant foreign laws, including Sharia, into the American legal system should be resisted. Thank you, Chairman Roy, Ranking Member Scanlon, and members of the subcommittee for inviting me here today to discuss the phenomena of alternative Sharia law-based institutions, why the enforcement by American courts of decrees issued by such institutions would be inconsistent with the fundamental rights guaranteed by the United States Constitution, and potential legal remedies to prevent such violation of fundamental constitutional rights. I'm an attorney practicing in the state of Louisiana for over 32 years. During the last 17 years, I've had the opportunity, largely on behalf of the Center for Security Policy, to research and study the interaction of foreign law, including Islamic Sharia, with American law. The interaction of foreign law with American law in American courts arises in four contexts: the enforcement of foreign judgments by American courts via comity, the application of foreign law in American courts through conflicts of law, the enforcement of choice of law clauses in contracts, the enforcement of forum selection clauses in contracts, the enforcement of arbitration clauses in contracts, and the transfer of lawsuits to foreign jurisdictions under the doctrine of forum nonconvenience. In all of these contexts, American courts and even American law enforcement could be called upon to enforce foreign law, even though the enforcement of foreign law would violate fundamental rights guaranteed by the United States Constitution. I've studied the numerous occasions in which foreign discordant law, including Sharia, has been litigated before American courts. Although the vast majority of foreign law applications are routine and do not violate American constitutional norms, over the past half-century, the number of cases adjudicating the application of discordant foreign law in American state courts, including through arbitrations, has steadily increased. The most prominent category of foreign law that has been increasingly intruding upon American courts is Islamic Sharia law, a body of law which consistently violates American public policy and fundamental constitutional rights, including the rights to equal protection, including equal protection based on race, religion, and gender, the right of due process, freedom of religion, and freedom of speech. Numerous tenets of Sharia show bias against women, the LGBTQ community, non-Muslims, former Muslims, and people designated as blasphemers. Courts in dozens of Muslim-majority nations and some non-Muslim nations currently apply Sharia. In hundreds of reported cases throughout the United States, litigants have attempted to apply Sharia, often succeeding. Examples include the enforcement of foreign child custody judgments or jurisdiction not based on the best interest of the child, but instead based on gender or religious discrimination. The transfer of cases to foreign countries whose courts discriminate on gender or religion. The enforcement of Islamic marriage contracts, dubbed Mars, as prenuptial agreements. Talaq or other Sharia divorces, and increasingly the creation of arbitration tribunals applying Sharia law within the United States. The law applied by such tribunals discriminates based on gender and religion, and in cases of custody disputes, does not apply the best interests of the child standard. Those arbitration tribunals also lack traditional American legal formalities, lessening due process. Furthermore, legislation of the past half-century has suppressed certain American legal protections against the intrusion of discordant foreign law. Public policy exceptions and common law rules have been overwritten by uniform acts adopted by the states, sometimes related to foreign treaties. Some uniform acts now treat foreign country judgments like sister state judgments, essentially extending the full faith and credit clause of the United States Constitution to foreign nations. Moreover, the U.S. Court of Appeals for the Ninth Circuit has explicitly held that foreign court orders are not subject to the constraints of American constitutional law. Responding to this encroachment of discordant foreign law into the United States, multiple efforts have been undertaken, primarily at the state but also the federal level, to address discordant foreign law. The model statute, American Laws for American Courts, passed in some form in 13 states to protect fundamental constitutional rights against the infiltration of foreign law, such as Sharia. Additional state acts and federal acts have also passed, including the Speech Act. Americans for over 250 years have toiled and suffered, including spilling blood, towards guaranteeing fundamental constitutional rights. No U.S. citizen should be denied the fundamental liberties guaranteed in our constitutional republic. The intrusion of discordant foreign laws, including Sharia, into the American legal system should be resisted. Thank you for your time, and I look forward to answering your questions.
Times of India videos, your daily dose of India and the world. Global news, different views, and sharp analysis.
Pressure of expectation from your fans, your supporters.
That has often served as a backdrop for several Bollywood.
You're not a brute majority anymore. If you individually take out Tera.
Making sense of global conflicts. Tracking the new emerging world order.
Strike on Israeli military bases.
A multi-pronged.
To stay out of harm's way as Israel started bombing targets across.
Understanding changing alliances in a polarized world. Tune into TOI videos for all this and more. Click on the bell icon to subscribe and never miss an update.